Welcome back to the Bald Guys of Bankruptcy. Today we're going to be discussing a recent bankruptcy filing that was all over the news, 23andMe. Let's jump right in. So where are we at and what does this mean?
Well, 23andMe, they're the leading direct-to-consumer genetics research company. They filed in March, so there are a lot of implications to this filing. When I think of this type of company, honestly, I think of 23andMe. So you would think they're a profitable, performing well company. But they're not, and there were some factors that led up to their bankruptcy. The company started in about 2006, and they did well right off the bat, but several factors led to really where they are now. One was market saturation, Ancestry.com, and there's a few others. So there's some competition, and there's also not a lot of repeat business. If you get your DNA tested, are you going to do it again? You don't need to do it again. So anyone who's interested in using the product, you've used it already. So not a lot of repeat business. And then honestly, there's a lot of security concerns with what they're doing with that information. And a lot of that leads into now this bankruptcy, where now they're going to sell their assets, and a lot of concern around who they're going to sell it to. That really led to the downfall of the company. But probably the biggest factor was the 2023 security breach. Hackers went in, stole a lot of the information. People lost a lot of confidence in the company there. You think your information is protected. I mean, it's very private information. It's your DNA, genome. It's broken down. It's your ancestry. It's your health risks, right? Now strangers have it.
So obviously, when a company files bankruptcy, many of the records, like the records of the bankruptcy docket, are available to anybody, right? So that's where you're pulling a lot of this information, right?
Right.
When you're looking at that, and I'm speaking more bigger picture, not just this bankruptcy, but when you're looking at that, are you getting a lot of information right away as to how the company performed over time?
Not much has been filed in the case. They haven't filed their schedules yet. So there's really nothing of public record right now.
Let's go more general, though. Forget this bankruptcy, right? What I'm asking is, when a company files bankruptcy, once everything is filed, and I get that in this case it wasn't filed immediately, but once everything is filed, should everything be filed, right? Do you then see, like, even down to that granular level of, like, this is how they did in 2018, 2019, 2020, or might you not see that?
Oh, you might not see that. It really depends on what they're hoping to get out of the case. If they're looking to continue operations, they have to file monthly operating reports. You're going to see how they're doing now. You might not see how they did 5, 6, 7 years ago, but you'll see a current status of the case and how they're operating.
And the reason why they'd be showing that is because if they wanted to keep going,
right,
they have to make a showing that they actually are going, or they're performing in a way that would warrant or justify them being permitted to continue.
Yeah, they have to show that they can still operate the business and increase value, or at least maintain value for their creditors.
Regarding the security concerns, wouldn't any new company or any purchaser have the same obligation to not use that data for inappropriate means?
Sure, and that would likely be part of the sale package, right? That they have to have at least the same level of security that 23andMe operated under. The problem is there's not a lot of laws that protect this type of company. Like HIPAA laws don't apply to 23andMe. There are certain federal laws, they're limited in scope, so that does provide some security. But again, yeah, a new company would have the same obligation, but they might not have the same motive, right? So they might use it differently. Think of if an insurance company were to purchase 23andMe, and how they would use that information. Now they know all your health risks. They'll probably raise premiums. Employers, now my employer somehow has this information. You might choose not to hire someone because of potential health risks. If you want to have even a broader scope, think of a foreign adversary, got it, and they want to use that information to develop bioweapons.
This brings to light, like, the fact that your information is out there and you think about it differently. Where, like, you mentioned the earlier security breach, right? So, like, you can't feel that great about 23andMe. They already had a security breach.
It's not like they intended for that to happen.
No, but what I'm saying is, I think that a lot of times when something's out there and there's an offering in the world, you go and do it. You're like, this is great. I want to learn about my DNA. Now I think you realize, like, well, there was a security breach at this company that really had to not get a security breach. Right? This is like an ultra-sensitive type of information. They have to be constructed to not have a security breach. They weren't a new company at the time, so presumably they're stable. You realize now that they're not, but you kind of look at it and you say, having it with any company is scary because you could have a security breach, and two, they could file bankruptcy. And when they file bankruptcy, where does that information go? And even if it stayed with them, there's a risk. So it's just an interesting situation where I don't know if it's just, we trusted 23andMe so much, now it's going somewhere else. I think this might even just bring to light, is this good to let this information go anywhere?
People see, maybe this wasn't a good idea. Maybe people got really just caught up in the hype early on, and you're more interested in, hey, I can learn about, health risks. I can learn about my whole ancestry line, people finding out that they had cousins they didn't know about and things like that. That's intriguing. People want to know that. But then when you weigh it against the risk that we see now as it played out, whoever is the eventual purchaser of 23andMe, whoever used 23andMe, didn't intend to use this new company. So there's really going to be no trust with the new company. Who knows? We'll see how it plays out. There's going to be a sale process through the bankruptcy. Those motions have already been filed and actually approved. So the court has already approved 23andMe's motion to approve their sale procedures.
They're approving the proposed procedures. They're not approving a sale right now.
Right, sale hasn't happened yet. Any sale would be in May. May 14th would be an auction date. So they have from now until then to try to get potential buyers. And they've been doing it all along. And they were doing it even before they filed bankruptcy. They were really doing the due diligence to see if they can find the potential buyer of all or some of their assets.
So you file in March, you try to sell in May. And outside of waiting for a sale, is there anything else important going on?
They had to file other motions to approve critical vendors, which we discussed in the Salt Life case. So if anyone wants to go back and watch that one. A couple of critical vendors, in this case, makers of their salival test kits, right? They don't make those in-house. They have another company that does that for them. They can't operate their business without those test kits. So they have to pay certain vendors ahead of others, or they can't run their business. Remember, they're a debtor in possession. So that means they're operating their business as they go through this bankruptcy. So they have to continue to make money. Can't make money without the test kits, and they don't pay the vendor, they're not going to have the test kits. So that had to be paid. And then they filed a motion to approve paying employees. You have to pay your employees. If they're not paid, they're not going to work. So there are a lot of things going on in the case outside of the sale. Like the sale, it's really the big event. It's the most attractive thing happening. But remember, they have to continue to run their business, and they have these other things going on to enable them to do that.
Since they're seeking to sell the business, are we anticipating historical information would not become available?
I think it will become available. I think any potential buyer would only be buying it for that information.
But would that become available on the docket, or that only becomes...
No, we wouldn't see that. That's still private. That wouldn't be filed on the docket, but it would be made available to the purchaser.
I do think it's interesting, because I think that when a business files bankruptcy to a total lay individual who just is interested in the company, love to know what information becomes available. If they were seeking to not sell themselves, right, some type of reorganization of their creditors, in that situation, we might see their historical information come available. But since they're looking to sell, that would only be really relevant to the buyer.
Right, yeah. The buyer would want to see it.
But we don't have to put it on the docket because we're only showing it to the buyers.
You don't have to put it on the docket. They're also seeking to get a stalking horse bidder, which they didn't have prior to the case. So that information would be made available to that company. And that's something they're hoping to do, because really the importance of getting a stalking horse bidder is just to lay that minimum bid for the sale. That gets the sale going. A company that takes on a risk but does its due diligence, places a bid on the property, and then that's how we get the bidding going. So that information will be made available to them, and then we'll see how it goes through the bid process.
Is this really considered like a liquidation? If you're selling the whole business, right?
Right.
When we think about consumer bankruptcy, 7 and 13s, right? We're thinking about either a 7 where we're just liquidating, right? Or a 13 where we're reorganizing. That would be continuing to operate, which is not happening here because we're going to sell the business, right? But I imagine if we were thinking in terms of liquidation, it's either sell the whole business or chop it up, either sell assets and parts of operations or just assets, right? So here we are selling the whole thing. It basically is a liquidation.
That remains to be seen. They may or may not sell the whole thing. They might have to chop it up and sell certain assets. It really depends on what gets bid on, what a potential purchaser wants to buy. They're trying to sell off even smaller assets, anything under $2,000. The court allowed them to either sell it or just abandon that property without further court order. So in a way they are kind of splitting it up. But if they have someone who comes and says, hey, I want this portion of the company, not that, and that's the best possible bid, if that is what enables them to achieve maximum value for the bankruptcy estate, then they'll do it. And then we'll see what they do with what's left. They either abandon it, try to sell it, or reorganize it. It is interesting. I was thinking, would I use a company like this? Probably not. Some of the fears that you see playing out, I probably share. But there's also that other factor. I'm curious. I want to know. I think I'd rather not know, though.
I wonder what this will do for the rest of the industry. As you mentioned, their competitors, Ancestry.com and others. I wonder what this will do for the rest of that industry.
Yeah, they might want to beef up their security.
And not file bankruptcy.
All right.
Thanks for joining us on the Bald Guys of Bankruptcy. So what do you think, Rich? Are we going to do a part 2?
I think we need to do a part 2. Can't wait for it. I'll see you there.
Bald Guys. Bald Guys. Bald Guys of Bankruptcy. Bald Guys. Bald Guys. Bald Guys of Bankruptcy.